Friends, we will make a beginning with the new topic, performance of contracts. We traveled from a situation where we learned what is contract, then what are the essential features of the contract, and elaborately discussed about free consent, consideration, lawful objects, and then capacity to enter into contracts, and what is a void contract, what is a waivering agreements, what is a contingent contracts. Now we are moving towards performance of a contract and what are the issues associated with the performance of a contract. First aspect to take up is what are the obligations of the party to the contract as regards to the performance. So basically, what is the question, friends? Once you enter into a contract, naturally you have to perform. Who need to perform? Both promisor and the promisee need to perform. Promisor has to complete what he promised and the promisee should complete what he accepted. Let us suppose I offered my building for the sale to Monica and Monica accepted the same for a value say 50 lakhs. Now I am ready to transfer my property to Monica, so Monica should also be equally be ready to pay me 50 lakhs. So I have to take 50 lakhs and transfer the property to her, and she need to pay 50 lakhs to me and take the possession and the registration in her name. So performance obligation is there on both the parties of promisor and the promisee. So now look at what is it. Parties to the contract must either A, perform or offer to perform their respective promises. That is the duty of the parties to the contract. No performance. Parties need not perform when performance is A, dispensed of, B, excused under the provisions of this act or under any other law. In case with a specific enabling clause in the contract, a particular performance is dispensed of with, that is the other party need not do this. Like that, if there is a clause, then we say performance is dispensed of, or it is non-performance is excused under the provisions of this act or under any other law, then one need not make the performance. So what are the obligations? That is, let us suppose somebody promised something, suddenly death of that person happened. Then also please remember, obligations under the contract still continue. Just look at representatives of the promisor, legal representatives of the promisor are bound to perform the promise where he is a promisor dies before the performance, but the representatives are not bound when it involves personal skill or of the promisor or there is no such a provision in the contracts. What does it mean? See, let us suppose Y is a doctor, he is a cardiologist. A patient got admitted in the hospital. He accepted to perform a surgery on that particular patient. Before the patient surgery, doctor died. Now the legal representatives cannot be, that is, they can't do the same surgery as what the doctor otherwise would have done, because that is his own skill, his own professional competence, that you can't expect what the legal has to have and complete that particular contract. And sometimes in the contract itself there may be a clause saying that if by any misfortune if death happens, there is no further obligations on the legal representatives. If that is the case, there is no need for the legal representatives to complete the performance, other than in a situation where performance does not include the professional skills or personal skills, and no such provision is there in the contract other than in these two situations, the obligation to complete the contract always continue to be there on the representatives of such deceased person. Then example, Z promises to deliver the goods to Y on certain day on payment of rupees 10,000. Z dies before that certain day. Z's representatives are bound to deliver the goods to Y, and Y is bound to pay the amount. Then F promises to paint a picture of Z by certain price. F died before that date. F's representatives are not bound to perform, nor can G insist on that performance, since it involved the personal skill of F. Right? See, these two examples you can find. In the second example, painting is a personal skill. Let us suppose my father is a good painter, that does not mean that automatically I will also become a good painter, is a point. Got it? So you can't expect whatever the contract that you entered with my father, where he has to exercise his personal skill to complete the contract, you can't expect me after him to continue with that particular contract and complete the obligations under that particular contract, because this is an exception which is permitted, wherein legal representatives need not complete that particular obligation, is a point. Other than that, if it does not involve personal skill or other way around, it is specifically excluded from the with an express provision in the contract. In any other situation, the obligations will continue to be there even to the legal representatives also, is a point to be well remembered, friends. Then the effect of neglect promisee to afford a reasonable facilities. Effect of neglect promisee to afford reasonable facilities for performance. What is it? Section 67 says, it is usual for the promisor to offer the performance to the promisee. On the offer by the promisor, the promisee is bound to afford reasonable facilities for performance. Where promisee neglects to provide or does not provide such reasonable facilities for performance, the promisor is excused by such neglect or refusal as to any non-performance caused thereby. For example, A contracts to repair B's house. B does not show him the places that require repair. A is excused for non-performance where it is so caused by B's neglect. That means, let us suppose when we enter into a contract, yes, I have to perform my duties, but at the same time, as a promisee who is expecting, who needed to get the services of mine, should show where the service is to be performed. I gave a contract to Monica to make my house clean and green and carry out wherever the repairs are required. She came along with the workers. She is asking us, sir, where do we start? What are all the things which requires repairs? If I keep silent and if I don't cooperate, can we expect Monica to complete the repair work? No. So, for performance, certain minimum facilities are to be provided. Let us suppose you are calling an electrician to your house. He has to fit, he need to fit a fan. Naturally, he expects you to give a small table. Certain facilities are to be given to him. Other way around, you can't expect that electrician to come with टेबल कुर्सी उसके ऊपर लगाने के लिए, वो सब उन्हें ला के नहीं करते ना. तो जब भी आप कॉन्ट्रैक्ट एंटर करें तो कॉन्ट्रैक्टर को भी कुछ फैसिलिटीज कॉन्ट्रैक्ट ही देना पड़ेगा. तो इन केस इफ देयर इज अ फेल्यूर ऑन द पार्ट ऑफ द promisee, definitely the promisor is going to get excuse on account of non-cooperation for making the performance by the promisee. Now, if a partnership firm obtains loans and all the partners signs the document, it would be liability of the partners to repay the loan. It is of no use of saying that there is an acknowledgement of a liability by a particular borrower as his sole liability. So, the point of interest is what? In the context of the partnership firm, when partnership firm takes the loan, then all the partners are jointly as well as individually, severally, are liable for the debts taken by the, what is it? The partnership firm is a point. So, signing the loan agreement is nothing but acknowledgement of the liability. Now, the next issue is offer to perform or tender of performance. What is it? Offer to perform or tender of performance. The offer of the promisor to perform must be unconditional, made to the promisee or one of the joint promisor or his or their authorized agent, made at proper place, time and form, made in such a manner and under such circumstances in which promisee has a reasonable opportunity to ascertain that promisor is able and willing to do the whole of his promise. In case of the delivery of the goods, promisee should be given a reasonable opportunity of inspecting those goods. So if you look at all these 5 things, for us to say the offer of the promisor to perform must be, how the offer to perform must be? Offer to perform must be unconditional. That is, the person who promises to do a particular thing should offer to do without keeping any conditions. Then made to the promisee or one of the joint promisor or his authorized agent. This promise to perform should be made to the either to the promisee or one of the joint promisees or his or their authorized agent, made at a proper place, time and form, made in such a manner and under such circumstances in which promisee has a reasonable opportunity to ascertain that promisor is able and willing to do the whole of his performance, promise. In case of the delivery of the goods, promisee should be given a reasonable opportunity of inspecting those goods also. So here friends, look at the points. This particular thing can be well understood only when you read the thing along with an example. That is, our contracts to deliver 100 bags of basmati rice at T's go down on a specific date. R should bring the whole lot of 100 bags to T's go down on specific date and offer T an opportunity of inspecting the same and ensure that 100 bags are there and it is of the same quality as contracted. So, offer for the performance means what? If in a particular contract, let us suppose one promises to supply to the other 100 bags of basmati rice, then what need to happen to say it as offer for promise? That is, one has to bring those 100 bags to the place where they are expected to be delivered, and a reasonable opportunity should be given to the other party to make the inspection of those goods, and those goods must be of the same quality as specified in the contract. If all these things happens, we say that performance, that is offer to perform has happened is a point. Then what are the effects of non-performance / part performance and non-acceptance of the performance. See, if there is a default, having entered into an agreement, if you make a default in performance, what will happen? That is default by the promisee. Section 38 deals with the default by the promisee, refusal to accept the performance. The other promisor is ready to make the performance, the promisee is refusing to accept such performance. Then that is, promisor has offered to perform the promise either to the promisee or to one of the several joint promisees. Promisee refused to accept his performance. Effect, promisor is not responsible for non-performance. Promisor does not lose his rights under the contract. So, what does it mean, friends? Let us suppose I am giving a contract of painting to Monica. Monica came along with the workers. I locked my house and went to Tirupati. On a specific date, she has to come along with the workers and the paint, and she should complete within 3 days. She came and we are not there. That means they are ready to perform, but we are not ready for acceptance. Then at a later date, can I say that Monica, you failed to perform, hence I am resigning, I am cancelling this contract? No. What she says, I came with an intent to complete that particular duty under the contract, whereas you are not ready by the date which is specified in the contract, so I am not at default. So the point of interest is, what is the effect of default in performance? Default in performance, in case if it is happening because of default by the promisee, that is who has to get the work, if he refuses to accept the performance, then whatever the rights the promisor has got, all he will have, because the default is not from the point of view of the promisor, but it is from the point of view of the promisee is the point to be remembered. So, promisor is not responsible for non-performance. Promisor does not lose his rights under the contract because he is ready to offer his part, whereas promisee is not ready for accepting those acts. Then friends, default by the promisor, part performance by the promisor. That is, promisee is ready to accept the performance by the promisor, but the promisor has refused to perform or disabled himself from performing his promise in entirety. Here what is happening? Reverse case. Promisee is ready to accept the performance, but promisor is not ready to make the performance or failed to completely complete the performance. Then what is the effect? Promisee may put an end to the contract. In such a case, he has to return the benefits, if any, he has received from the part performance of the promise, where the promise has signified by the words his consent to continuance of the contract, he cannot put an end to it. Promisee is entitled to the damages on account of non-performance by the promisor. So what are all the things that will happen here, friends? What is the effect for non-performance is most important. See, I gave a contract of painting of my house to Monica. She said, sir, tomorrow I will bring to your house the color tins, paint tins. She brought it and kept it in my house. Tomorrow I will come along with the workers and start the work, sir. That tomorrow's gone. Even after 10 days workers are not coming. Then I telephoned to Monica, said, Monica, this is not good on your part, so I am cancelling the contracts. Can I do it? Yes. Only thing what I have to do, I have to give back whatever the benefits that I got under the contract, that is, आपका टिन्स पेंट टिन्स आप ले लो. But try to understand, because of your not painting, I suffered with some loss. What kind of loss, sir? Actually, a business meet is expected to happen in my house. Those people came and they saw my house. They said, this dirty you kept without having a whitewash for your house, so we are not interested to go ahead with you in a business relationship. I suffered. So on account of whom? On account of you, because I already entered into a contract with you to complete the work within 2-3 days, but you are not in a position to complete it, so I suffered, then you have to pay the damages. Then where the promisee has signified his consent to continuance of the contract, he cannot put an end to it. That is, after 10 days Monica telephoned, instead of my telephoning, Monica telephoned. Sir, sorry sir, we got a very big contract, so all my workers are packed, shall I do now? If I say yes, later on I cannot say, after her coming to me, that no, please don't do. Like that I can't say. So second B point is what? Where the promisee has signified by words or conduct his consent to continuance of the contract, he cannot put an end to it. Then example, Z, a singer, agrees with H, the manager of a theatre, to sing 2 nights every week during the next 2 months, for which H promises to pay 1000 per performance. G performs for 1 month but does not turn up in the next month. H can terminate the contract. Even if a part performance is made, remaining part is not made, then contract can be very well be terminated. It's a point, friends. In the above case, G turns up in the 2nd week of the 2nd month, and H, without saying anything, allowed G's performance that night. H is impliedly given his assent to continuance of the contract. He cannot repudiate the contract but can claim the damages from G for failure to sing in the prior week. So by words or by conduct, if you allow promisee to continue to perform, then later on you cannot resign. Only thing is that you can, whenever there is a failure on the part of the promisee to do the work, because of that, if you suffer, you can always claim damages from the promisee, is the point. Then, who can demand the performance of the promise? Who can demand the performance of the promise? Who should perform the promise? Can a third party to the contract offer the performance? If so, what is the legality? तो कौन डिमांड करना प्रॉमिस, परफॉर्मेंस ऑफ द प्रॉमिस के लिए कौन डिमांड करना? Naturally, promisee has to demand on the promisor to complete the promise. So, demanding performance of the promise, only promisee can demand. Only the promisee can demand the performance of the promise. In case of a contract for the benefit of the third party also, only the promisee can demand the performance. Third party, in certain cases, third party can also enforce the performance of the promise. For example, an agent on behalf of the principal. Monica is acting as an agent of Chakravarti. Chakravarti has got a contract with Suresh. That is, Suresh need to, what is it? Complete the Word document and the PowerPoint and bring it to the class at least half an hour before the, what is it, the class. And Chakravarti made Monica as an agent of him. Now Monica can very well ask Suresh, Suresh, where is the work? Then Suresh cannot say to Monica, who are you? Who are you asking? The contract is between me and Mr. Chakravarti. Chakravarti is the promisee. Let Chakravarti come and ask for the performance. No, Suresh. As per the law, if I am appointing somebody as my agent can also come and ask you for the performance. Who said so? Contract Act says so. That is third party. In certain cases, third party can also enforce the performance of the promise. For example, agent on behalf of the principal. Representative, on the death of the promisee, his representatives can demand the performance. So, promisee himself can demand the performance. Agent can also demand the performance. On the death of the promisee, his legal representatives can also demand for the performance is a point. Performance of the promise. Section 40, 41, 42. Who has to do the performance? Promisor has to do the performance. So, where it appears from the nature of the case that parties intended performance of the promise by the promisor himself, then only promisor should perform such promise. In most of the cases, it may involve the exercise of the personal skills by the promisor. For example, painting of a picture, performance of a dance, song, etc. Let us suppose Monica came to our academy and she saw Kalyan Chakravarti will teach accounts. She paid the fees. Now Karthik is coming and teaching. Now can she demand that only Chakravarti should come and teach? Yes. Because there with what understanding she has paid the fees, the Chakravarti will make the teaching of that. So academy cannot change the teacher like that, because teaching, painting, singing, dancing, these are all the personal skills, involving the personal skills.